Hi, I'm Annie Fitzsimmons. I'm your Washington REALTORS legal hotline lawyer. And today's video is another in our series of mistaken identity for forms. Now, in this video series, we've already talked about the mistaken identity between Form 35R for the purposes of terminating a transaction with the misuse of Form 51, the rescission agreement. In this video, I want to broaden the discussion to make sure you understand that any time buyer or seller has the unilateral right to terminate the transaction, anytime the buyer or seller has the unilateral right to terminate the transaction, you would be using the wrong form if you use a Form 51. So buyer has the unilateral right to terminate the transaction when buyer timely exercises their contingency right under the financing contingency, the inspection contingency, the title review contingency, the HOA doc review contingency. Pick whatever contingency there is benefiting the buyer. If the buyer has that contingency and they want to terminate the transaction timely, they have the unilateral right to do so. Seller has the right to terminate the transaction. In other cases, buyer fails to timely provide evidence of the conversion of their contingent funds to non-contingent funds under the Form 22EF. Seller has the right to terminate the transaction. Seller delivers notice to perform under the Form 22A. Buyer fails to waive their financing contingency. Seller has the right to terminate the transaction. When a party has the right to terminate, that means it should require only the signature of the party who's terminating to effectively terminate the transaction. Their signature delivered to the other party during the term of the contingency terminates the transaction. The transaction's gone. It doesn't require any acknowledgement, acquiescence, acceptance from the other side. But brokers, in any of those instances, or any other one, where either party has the unilateral right to terminate the transaction, and instead of using the proper notice form, and I think all of those notice forms, with the exception of the inspection contingency, which is Form 35R, I think all of those notice forms are housed within the Form 90 series of forms. I could be wrong. 22A has a 22AR, where buyer would use to terminate. So there are some exceptions. But most of the notice forms, including the termination notice forms, are housed within the Form 90 series of forms. If you want to terminate, if your client wants to terminate based on the unilateral right to terminate, and you can't find a termination notice specifically for that termination. For example, I don't think that there is a termination notice specifically for the seller terminating under Form 22EF. In that case, you would use a blank Form 90. You could model your language around the termination provisions in some of the other termination notice forms, and you would draft your own termination notice, requiring only the signature, in that case, of seller, with timely and proper delivery to the buyer broker, and with that, seller has effectively terminated the transaction. Now, the parties may or may not have an earnest money dispute that needs to be resolved separately. The earnest money, disbursement of the earnest money should always be set forth on a Form 50. You do not need a Form 51 to disperse the earnest money. You would use a Form 50 to disperse the earnest money. So a termination notice along with the earnest money disbursement both get delivered to the other side. Even if the other side objects to the earnest money disbursement, your client has timely and effectively terminated the transaction, which was their goal. And now they can move on, either to buy another house or sell that house to another buyer, and worry about the earnest money separately if they have to do that, if there's not agreement on the earnest money. If you have questions on this topic or any other, go to the legal hotline at warealtor.org and send me a question. Thank you for being a Washington REALTORS member.